Our next speaker, he's quite a remarkable man. He's a physician, a three-term elected representative from the state of Oklahoma. He was born in Trenton, Missouri. He's married to his lovely wife, Connie, for over 37 years. They have 4 children. Mike is an ordained Southern Baptist deacon, Sunday school teacher at the Arrow Heights Baptist Church. Mike is a cancer survivor for over 33 years. He and Connie have served as medical missionaries to Mexico and Honduras. Now, I can't read all of his accomplishments because it's 3 full pages. I mean, it's amazing, this man's background. He's graduated cum laude from college. He served in the military. He's delivered over 2,000 babies. I mean, there's so many things that he's done that most of us, and he even has a degree in zoology. I don't know. I think you're really going to enjoy Dr. Michael Ritze. Doctor.
Thank you, Mr. Fitzgerald. Ladies and gentlemen, members of the council, yes, members of the John Birch Society. This is extremely one of the greatest honors I've had. I've addressed the council in the past, but not as a legislator from the great state of Oklahoma. These are interesting times that we're living in. I do a lot of joking, had a lot of fun. People asked me when I first got elected to the legislature in my hometown of Broken Arrow, which is a southeast suburb of Tulsa, if I could get along with people. Jim mentioned that I've delivered 2,000 babies, and if you can get along with 2,000 pregnant ladies, you can get along with anybody. Tonight I want to talk to you a little bit about nullifying Obamacare. Now you all have heard about, I'm sure, the book by Dr. Thomas Woods. If you haven't read it, you've got to read it because it inspired me. And of course, the New American, as a charter member of the New American, I believe totally is one of the best, well-written, well-researched, documented magazines that we have in America today, and we use it in the Oklahoma legislature. We use it for research. We use it even when our children, we homeschooled 3 children. Our fourth child passed away, but the 3 children, and homeschooled them. My wife is a RN, BSN. She got bored, so she's finishing a master's in nursing education. And those 3 children are the pride of our lives. One's an attorney, one is a physician, and the other one is an aspiring highway patrolman at this moment. And we look at what the Birch Society has meant to us, and a lot of the information you probably are familiar with, but I hope to enlighten you. In the New American this year, recently in August 2012, they talked about a 5-4 decision that the Supreme Court upheld the joint venture of the President and the Congress to force every American, all of us, regardless of ability or desire to purchase a qualifying health care insurance plan by 2014 or face a tax penalty for a failure to comply. The court's June 28th ruling demonstrates a bizarre interpretation of the Constitution, wherein the majority of the justices held that while the Constitution does not grant Congress the power to compel the purchase of a commodity, it does have the power to tax anyone who doesn't want to make such a purchase. Chief Justice John Roberts, writing for the court, held while the individual mandate, and by the way, I've read ObamaCare, the law, the bill, twice. My wife, as a nurse, has read it once. The President says he hasn't read it. Nancy Pelosi said she hasn't read it. My governor, most of my colleagues in the Oklahoma legislature haven't read it. I keep it on my desk at the state capitol, labeled in big bold letters, Obamacare, on my three-ring binding folder. And anybody that comes in the office gets to see that, as well as lots of Birch literature in my office at the Oklahoma Capitol. And Chief Justice Roberts was writing for the court. He held, while the individual mandate is not a valid exercise of Congress's power under the Commerce Clause and the necessary and proper clause, it is valid as an exercise of the taxing power granted the federal government by the Constitution. In her partial dissent, Justice Ruth Bader Ginsburg disagrees with the Chief Justice's interpretation of the constitutional limits of the Commerce Clause. Ginsburg writes, when contemplated in its extreme, almost any power looks dangerous. The commerce power hypothetically would enable Congress to prohibit the purchase and home production of all meat, fish, and dairy products, effectively compelling Americans to eat only vegetables. It's a bunch of hogwash, obviously, but yet no one would offer the hypothetical and the unreal possibility. There's lots of case law that they revert to, and I read the day it was hot off the press, I read Judge Roberts' and the court's decision and critiqued it. And Ginsburg goes on and says, of a vegetarian state as a credible reason to deny Congress the authority ever to ban the possession and sale of goods. And Ginsburg said, therefore, she believes that concerned citizens and constitutionalists should not worry about the future imposition of a vegetarian state. Because if it's just hypothetical, that isn't to say, however, that Congress couldn't make such a mandate under its broad Commerce Clause and power, she insists. Furthermore, don't be fooled by the Chief Justice's more narrow reading of the Commerce Clause. While he rightly reasons that Congress's power to regulate commerce is limited and not intended to place all behavior within the power of Congress to control, his analysis of the individual mandate as an expression of the taxing power makes it clear that, in his opinion, the taxation clause gives Congress that immense and unlimited power, even if the Commerce Clause does not. Then, lest anyone misunderstand exactly what will now be required under Obamacare, the court declared the most straightforward reading of the individual mandate is that it commands individuals to purchase insurance. Your federal overlords now command you to purchase a qualifying health care plan and will impose an additional tax should you refuse to obey. In a fair reading of the decision, the Supreme Court says that the penalty for failure to purchase health care insurance is not a tax for the purpose of the application of the Anti-Injunction Act, but it is a tax for the purpose of interpreting the taxing power of the Constitution. The relevant portion of the majority opinion reads, the Affordable Care Act describes the payment as a penalty, not a tax. We know on and on the president promoted it all through the whole process. This is not a tax, this is not a penalty, and so on and so forth that he's eating his words about. But that label cannot control whether the payment is a tax for purposes of the Constitution, but it does determine the application of the Anti-Injunction Act. The Anti-Injunction Act, therefore, does not bar this suit. Given the fact that the Affordable Care Act explicitly states that the individual mandate penalty is not a tax and that its proponents universally defended the provision on that same ground, what Chief Justice John Roberts did amounts to no more or less than scrapping Obamacare and now giving us Roberts Care. As the states have become servants, they may yet regain their proper role as masters. In this, there is hope. The states, through the exercise of the 10th Amendment, as the sovereign entities that they should be. And keep in mind that our founders told us that the states created the federal government, not the other way around. and they are to answer to them whenever something is unconstitutional, clearly unconstitutional. And so we're here tonight as Texans, as Oklahomans, as other individuals of the sovereign United States, realize that we can take back that power. As John McManus says many times, the first 10 amendments to the Constitution or the Bill of Rights are kind of like the 10 Commandments, where the founders said, thou shalt not, thou shalt not. And when they got down to the 10th Amendment, they said, you cannot do that either without the approval of the states. So now as we see the states, through the exercise of the 10th Amendment and their natural right to rule as sovereign entities, may stop Obamacare at the state borders by enacting state statutes nullifying the health care law and criminalizing the state participation in administering or executing the unconstitutional provisions thereof. Nullification, and you'll also, Dr. Woods talks about, also here it is called interposition. Madison, Jefferson used the term interchangeably, but they said that nullification is the rightful remedy and is very effective and constitutionally sound method of checking federal usurpation of power. That said, there is no reason that concerned citizens should not use every weapon in the constitutional arsenal, including working to convince Congress to repeal this offensive act. I also have spoken at society functions and on speaking tours for the society. And by the way, I'll be in Midland and Dallas in December. We'll be talking about this further. But I've always emphasized that no matter what happens, the states should and will stand up, as we have in Oklahoma, as I will give to you an example here shortly. But ironically, the Supreme Court's decision placed a powerful weapon against ObamaCare in the state's arsenal. In the majority opinion, Chief Justice Roberts held that the federal government could not withhold Medicaid funds from states that reject the expansion of the health care program as required by the Affordable Care Act. Now, what that means is that the states, it's an unlawful law. We still can tax you because we've got the taxation power under the Supremacy Clause, and we'll go into that amendment where that is a misunderstanding. But he also pulled the caveat that the states, which love that money for Medicaid, for more votes, for more welfare recipients, for more illegal immigrants coming in, for free programs to have building a base. He held out and truthfully said that they can't tell the states what to do about the Medicare money. So what that means and what's going to happen now is, in fact, that the states who refuse the expansion may shift the financial burden back to the federal government funding, or Medicaid completely back onto the federal government, in an act that some estimate could cost the federal government an additional $230 billion in the new exchange-based subsidies, for a net added cost of over $100 billion in just the first year under Obamacare, under the Obamacare scheme. As many Americans know all too well, Obamacare already comes with a price tag of over $2.5 trillion from 2014 to 2024, a behemoth boondoggle that will add more than $823 billion more to the federal deficit. Add that to the wrinkle in the Obamacare fabric, the fact that most states have yet to set up an exchange as mandated by Obamacare. In Oklahoma, immediately we were offered bribes through stimulus money. Our governor took $54 million as a bribe, and we started a campaign with the Birch chapters and the Tea Party groups and many others, and forced the governor to send it back, and I got called in her office and pointed a finger at me that I was the reason she's having to send back this $54 million, and I said, no. And I said, no, Governor, it wasn't me, it was the people. And she knew it. And she knew it. So what happened is many of those states have Republican governors, as we do and you do, in name only, who adamantly refuse to participate in the exchange altogether. The Cato Institute estimates that as few as 15 states now are likely to have exchanges in operation for the 2014 deadline of Obamacare. So now, never fear, it's Obamacare to the rescue, because what has happened, the relevant provisions in the Act authorize the federal government to pinch hit for the recalcitrant states and set up qualifying health care exchanges, insurance exchanges, that may sound like a pretty effective squeeze play, but there is no way that Congress can find funds to set up 35 or more exchanges in those states where the governors or the legislatures assert their sovereignty and refuse to accede to the unconstitutional demands of Obamacare. Besides, only those exchanges that are established by the states are eligible for subsidies. So if your state does not have a state exchange, then Obamacare cannot come into Texas, the way I read it. Oklahoma has not established, and I have debated it on the House floor on many occasions to stop those individuals in the legislature that wanted to have a state exchange set up, and we were able to convince them, thanks to many of our Birchers in Oklahoma and across the country, explaining to them that it is a backdoor approach to Obamacare. So, no, with a line through it, no exchanges. The exchanges, Obamacare doesn't provide for subsidies paid through the exchange that was set up and managed by the federal government. Therefore, if enough state legislators and governors can be convinced by their constituents to stand up for their rights of self-government and refuse to accept either the offer of the Medicaid funds or the establishing of qualifying health care exchanges, it will be impossible for Obamacare to accomplish a hefty portion of its new entitlement spending provisions. States may yet play another important role in gutting Obamacare. Those federal subsidies that states can essentially nullify by their refusal to set up exchanges are the trigger that imposes penalties on employers who don't provide their workers with health care benefits. So by deactivating the trigger, states can simultaneously diffuse the employer mandate provision of Obamacare as well. Now in Oklahoma, 3 years ago, Senator Randy Brogdon and I authored legislation, SJR 759, to allow our citizens to opt out of the Obamacare mandate. The liberal governor at the time vetoed our bill. Went through both houses, the legislature, Senate, and the House and the Senate, and he vetoed it. So we immediately turned around, Senator Brogdon and I, we turned right around and we changed our bill into a constitutional amendment that went to the vote of the people and passed by 64%. It is now law in Oklahoma that the mandate can only be enacted if an Oklahoma citizen chooses to participate. I recently wrote a letter to our Attorney General asking him how he will defend this law, and I'd like to read it to you. Dear Mr. Attorney General, because of the recent ruling by the United States Supreme Court and the National Federation of Independent Business versus Sabellis, with respect to the mandate of the federal law, which will require all persons to acquire some form of health care insurance, I am writing you to ask questions about the effect of the ruling. With regard to the lawsuit, which I assume is still pending in the Eastern District of the Federal Court of the State of Oklahoma, ex-relevant Scott Pruitt, our Attorney General versus Kathleen Sebelius et al., will your office continue to litigate that case? What action will your office take if an Oklahoma citizen or resident who might otherwise be required by the provisions of the federal statute to acquire health care coverage asserts a right under the recently adopted provisions of Article 2, Section 37 of the Oklahoma Constitution not to acquire such coverage, which was the SJR I just mentioned that we passed. We amended our Constitution by 64%. This was June 23rd this summer. My question, would the Attorney General intervene in any litigation or administrative action in which such an Oklahoma resident would be a party, defendant, or respondent in order to assert the right of that individual to rely on the provisions of Article 2, Section 37 of the Oklahoma Constitution to prevent the individual from being required to comply with the mandate imposed by the federal health care law? Does the Attorney General's office anticipate any other action, whether by litigation or participate in litigation filed by another state or states in order to enforce the provisions of the Oklahoma Health Care Freedom Amendment as reflected in the provisions of Article 2, Section 37 of the Oklahoma Constitution? Signed respectfully, Representative Mike Ritze. So then I got an answer. It took them 6 weeks, but I got an answer to my letter on September 11th. And he said, "Dear Representative Ritze, we are in receipt of your letter dated July 23, 2012, in which you ask several questions relating to the effect of the United States Supreme Court ruling in the National Federation of Independent Businesses versus Sebelius. Because this office is currently engaged in litigation involving matters related to your questions, we will not be issuing an official Attorney General opinion in response to your questions." First of all, I didn't ask them for that. I just asked them questions, but anyway, they interpreted that. However, it would be noted that Sebelius Court held that while the federal government cannot mandate Americans to buy health insurance, it can tax those who do not, because Article 6, Clause 2 of the United States Constitution, known as the Supremacy Clause, establishes that federal law shall be the supreme law of the land. Article 2, Section 37 of the Oklahoma Constitution is now ineffective. To the extent it purports to prevent such a tax from being levied, but remains effective as a protection against any mandated purchase of health insurance. As the above referenced litigation progresses, more details regarding the office's position will become available through the pleadings filed in that case. Respectfully signed, the Attorney General, by his Assistant Solicitor General Weyrich. Well, there's nothing like getting an old German feather Indian upset about something like that response. So the next day I fired off a letter back to the Attorney General. And I said, "Mr. Attorney General, I recently wrote you about defending Oklahoma citizens from Obamacare, and your Solicitor General, Mr. Weyrich, responded, and I'm very concerned your interpretation of the Supremacy Clause, as some have wrongly called it, of Article 6 by many constitutional scholars, stated does not declare that the Constitution is the supreme law of the land." You know, having homeschooled 3 children, having been a college professor and having 3 college degrees and being homeschooled by the John Birch Society for 31 years, I wanted to homeschool this guy. So I said to him in this letter, what it really says in the Constitution, it says, quote, "and the laws of the United States made in pursuance thereof," end quote, "are the supreme law of the land." In pursuance thereof, not in capitals, in pursuance, and capitals bold, in violation thereof, the Obamacare tax is not permissible under any enumerated power given to Congress in the Constitution. Therefore, was not made in pursuance of the Constitution, therefore is not the supreme law of the land. Representative from Texas, my colleague, Representative Simpson, I'll be glad to share that with you, because we set them straight and we said the Constitution further of the United States was created by the states and given very few powers over objects of national importance. And I quote, as James Madison said in Federalist 45, "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite." The former will be exercised, as Madison further states, the former will be exercised principally on external objects as war, peace, negotiation, foreign commerce, and with which the last power of taxation will, for the most part, be connected. The powers reserved to the several states will extend to all the objects which in the ordinary course of affairs concern the lives, liberties, and properties of the people and in the internal order, improvement, and prosperity of the state. I further said to this Attorney General and his lackey, nowhere in the Supreme Court decision in the law itself does Obamacare purport to be an object of war, peace, negotiation, or foreign commerce. In fact, in the law and its supporters' defense thereof, it is always described as something that concerned the lives of all Americans. Legislating in such a matter certainly is a power retained by the states under the principle of federalism, and a plain reading of the 9th and 10th Amendments, and by the way, I've enclosed a copy for you, Mr. Attorney General. As Justice Anton Scalia said and wrote in his dissent, for all of these reasons, to say that the individual mandate merely imposes a tax is not to interpret the statute, but to rewrite it. Judicial tax writing particularly is very troubling. Taxes have never been popular. Remember the Stamp Act of 1765 and its part that reason the Constitution requires tax increases to originate in the House of Representatives. See Article 1, Section 7, Clause 1, that is to say, they must originate in the legislative body most accountable to the people, where legislators must weigh the need for the tax against the terrible price they might pay at their next election, which is never more than 2 years off. At least, number Federalist 58 defended the decision to give the origination power to the House on the grounds that the chamber that is more accountable to the people should have the primary role in raising taxes. Now, I haven't received any response to that letter yet, but I'll be glad to let you know when I do. So what has happened here, as we've seen here with this, circus that they're trying to go around the legislators, only makes us more dedicated to make sure that we get rid of this terrible law. 2 years ago, I authored a bill, House Bill 1276, to completely nullify the ObamaCare in Oklahoma. First, we did the opt-out of the mandate to give our citizens a choice, and then we followed up with the nullification of the whole law. It passed in the Oklahoma House Judiciary Committee, which leadership always tries to put it in front of a bunch of lawyers to intimidate a doctor, and it passed 12-4. We got it out of committee, and the Senate got out of their committee, and it sat there. Because of our gutless House leadership, it was never brought to the floor for a vote in 2011, 2012, Oklahoma legislative sessions. So, I will draft it again. This legislative session, they'll change the number of the bill, but it'll be the same bill. It'll be assigned to a different number, but the substance will be the same. And anybody wants a copy, they can go to the Oklahoma House of Representatives and we'll send you a simple copy of the bill. But it does say some interesting things. Representative Simpson, I know, and several Texas legislators are looking at this for your great state. And the bill basically says, as introduced, to public health and safety, making legislative findings, making certain declarations. And goes on with certain verbiage that we do properly in the legislature and lawyer talk and so on and so forth. But I want to get down to, we always try to educate them, we always try to birch them, so they have to read it and get a little bit of information from the Birch Society. But the people of the several states comprising the United States of America created the federal government to be their agent for certain enumerated purposes as set forth in the United States Constitution and nothing more. The 10th Amendment to the United States Constitution defines the total scope of the federal powers as being those which have been delegated by the people of the several states to the federal government, and all powers not delegated to the federal government in the Constitution of the United States are reserved to the states, respectively, or to the people themselves. Furthermore, as stated in the 9th Amendment, in this House Bill 1276, the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, and the assumption of the power that the federal government has made by enacting the Patient Protection and Affordable Care Act and the Health Care and Education Reconciliation Act of 2010 is nowhere expressly granted by the United States Constitution, and interferes with the right of the people of the state of Oklahoma to regulate health care as they see fit. And in a new law, a new section of the law to be codified in the Oklahoma statutes is Section 1 to 125 of Title 63, unless there is created a duplication in the numbering, reads as, the legislature of the state of Oklahoma declares that the federal laws known as the Patient Protection and Affordable Care Act and the Health Care and Education Reconciliation Act of 2010, signed by President Barack Obama on March 23rd and 30th, 2010, are not authorized by the Constitution of the United States and violate its true meaning and intent as given by the founders and ratifiers, and are hereby declared invalid in Oklahoma. Shall not be recognized by this state, are specifically rejected by this state, and shall be considered null and void of no effect in this state. And furthermore, it shall be the duty of the legislature of this state to adopt and enact any and all measures as may be necessary to prevent the enforcement of the Patient Protection and Affordable Care Act and the Health Care and Education Reconciliation Act of 2010 within the limits of the state. And listen carefully. And if any official, agent, or employee of the United States government or any employee of a corporation providing services to the United States government that enforces or attempts to enforce an act, order, law, statute, rule, or regulation of the government of the United States in violation of this act shall be guilty of a felony. And upon conviction, shall be punished by the fine not exceeding $5,000 or a term of imprisonment not exceeding the 5 years or both. Now the next paragraph is where the governor had some real heartburn, and it's going to come down to some real negotiation, because I said any public officer or employee of the state of Oklahoma, the governor, that enforces or attempts to enforce an act, order, law, statute, rule, or regulation of the government of the United States in violation of this act shall be guilty of a misdemeanor, punishable by imprisonment in the county jail not exceeding 2 years, or by a fine not exceeding $1,000, or both such fine and imprisonment. Any aggrieved party shall also have private cause of action against any person violating the provisions of this subsections C and D that I just read of this bill. The last part of it is being immediately necessary for the preservation of the public peace, and emergency clause is attached to mean that as soon as the governor signs it, it goes into law. Now, if the employer mandate states that businesses with 50 or more workers have to provide health insurance to their employees or pay a penalty, or as Chief Justice Roberts now calls it, a tax under ObamaCare as passed by Congress but not as rewritten by the Supreme Court, That penalty is assessed if at least one of the company's employees qualifies for subsidies under the exchange. However, since those subsidies are not made available through a state-managed exchange, any state that refuses to set up an exchange could effectively nullify the employer mandate completely. As a final word on this point of the state's ability to repel the encroachments of Obamacare, if health insurance rates increases under Obamacare, as many experts have argued they will, many smaller businesses, those with just over 50 employees, could be forced to drop their health insurance policies. If that were to happen, not only would Obamacare not insure the uninsured as promised by its promoters, but it would rob thousands of workers of the health benefits they once enjoyed before their bosses were priced out of the market. Americans concerned about the continuing freedom of our great republic must now turn their attention to removing from office every senator, every U.S. congressman, representative who voted in favor of the madness that is now called the law of the land. And that's where you come in. Further on, concerned citizens must work to elect candidates for state legislatures that will stand up, assert the 9th and 10th Amendments, who will commit themselves to boldly asserting the sovereignty of the states and forcing this raging bull of the federal government back within the small and well-defined corral built by our founding fathers. You know, it's summarized in a little quick sentence. It says, so let me get this straight. This is a long sentence. So we're going to be gifted with a health care plan we are forced to purchase and find if we don't, which purportedly covers at least 10 million more people without adding a single few new doctor, but provides for 16,000 new IRS agents, written by a committee whose chairman says he doesn't understand it, passed by a Congress that didn't read it but exempt themselves from it, and signed by the president who smokes, with funding administered by a treasury chief who didn't pay his taxes, for which will be taxed for 4 years before any benefits take place or effect, by a government which has already bankrupted Social Security and Medicare, all to the overseen by a Surgeon General who is obese, and financed by a country that's broke. So what the blank could possibly go wrong? You know, there's always hope. You all are making a stand tonight by being here. Oklahomans are making a stand by supporting us, and we have an overwhelming support in our state. We were the reddest, as most of you know, states 3 or 4 years ago. All 77 counties were red, and even Obama in the presidential primary only this year in March only got 55% of his own party's votes. So we know Oklahomans are behind us. We know Texans are behind us. We know that the John Birch Society is the ones that are providing the leadership, and I hope if you're not a member, you'll join to give us more presence, because we just added 2 more Birchers to the Oklahoma legislature for a total of 6, and a possibility of 3 more after the general election. My wife and I and family pray for the John Birch Society and their members and their staff every single day, and sometimes more often than that, because we know that if it would not have been for the John Birch Society, we would have been long gone into socialism. Now, there are times that we all get down, and as believers in our Lord and Savior Jesus Christ and biblical scholars, I won't bore you anymore, but I have to close with one of my favorite stories. We all know that in the book of 1 Samuel, the 17th chapter, there was a little known shepherd guy by the name of Dave that was called upon by his people to go out and take on a big guy, a big giant, kind of like the Oklahoma-Texas game last week. And anyway, sorry. Anyway, David went out, and God's preparing him. He's putting on the armor through 1 Samuel 17:33 and on through 34 and down to 37. And when you get down in your deepest thoughts and you're thinking about that there's no hope and there's no chance and we got this Goliath out there that's coming at us, just remember we've got the Birch Society, and we definitely have Almighty God, because what God said, and let me read this in 1 Samuel 17:47, and all this assembly shall know that the Lord saveth not with sword and spear, for the battle is the Lord's, and he will give you into our hands. So we know that Almighty God is on our side. God bless you, the John Birch Society, America, and thank you so much for your attention.